Good morning, everyone. We will kick off shortly. I'll just give people a couple of minutes just to join while the numbers are going up. But in the meantime, if you get the chance, you might complete the polling questions that are appearing on screen, and we might run through the results of those towards the end of the session. Thanks. Good morning, everyone. My name is Rowena Fitzgerald, and you're very welcome to the second installment in our series of webinars that looks at key topics in the financial services regulation space. The subject matter for today's discussion is definitely one that has occupied the thoughts of every director and senior manager in a regulated financial services provider, and that is the challenges you face when you're seeking to promote good governance, consumer-focused cultures, and high standards of conduct within your business. And while these are topics that the central bank continually focuses on and emphasizes, they can be difficult to understand, let alone achieve within an organization. And that's really the purpose of our discussion today, is to try to tease out what these concepts actually mean for your business. Just to note that the session itself will be recorded and it will be available up on the MHC website over the next few days. We also publish a number of easings throughout the year, so please do feel free to sign up for these, and we'll do our best to keep you updated on developments in the financial services space. Firstly, just to introduce our panel, we're delighted to be joined by our guest speaker today, and that's Sylvia Cronin. Sylvia brings a wealth of board experience with her. And is a chartered director sitting on the board of a number of regulated financial institutions. We're also joined on the panel by my partners, Claire Lord, who heads up our corporate governance and compliance team, by Peter Johnston, who's a partner in our dispute resolution team and who has particular expertise in advising financial institutions and also dealing with and advising on central bank enforcement matters. And also my fellow FinReg enthusiastic person is Liam Flynn, who co-heads the financial services regulation practice here with me in MHC. And before we jump into the discussion itself, and perhaps to set the scene a little, in terms of where we've seen governance issues and culture being brought into sharp focus for our clients, is where a client might receive, for example, a risk mitigation plan from the Central Bank of Ireland or an RMP. What that will often do is, you might have a financial institution that goes through a period of, say, rapid growth or significant outperformance against the plans that previously provided to the central bank, and that will prompt the central bank to question whether that institution is properly structured and resourced to ensure proper governance and culture and conduct within its organization. As part of that RMP, the central bank might ask the board to confirm that it will undertake a detailed review and document how the board is satisfied that it does have adequate governance and culture and conduct frameworks in place. So at that point, a board and the senior managers within a firm might be thinking to themselves, where do we even start with a question like that? And given the various backgrounds that we have on the panel today, I'm hopeful that we can cover many angles when it comes to governance and culture and conduct and how to achieve that within an organization. I would ask, if you do have questions, though, please do feel free to pop these into the Q&A function on the screen, and we leave aside a bit of time at the end to run through as many of those as we can. And in the meantime, I'll certainly have plenty of questions for our panelists today as well. But before I jump into that, I'd like to invite Sylvia maybe to give us some opening remarks and her thoughts on this whole area. So again, thank you, Sylvia, for joining us today, and over to you.
Thank you. Great, thank you. Can everyone hear me?
Yeah.
Yeah, perfect, thank you. Okay, well, good morning all. Firstly, I'd like to thank Liam, Rowena and the team for inviting me here today to share my experience on the important topics of governance, conduct and culture. I suppose in my over 30 years in financial services at this point, I've definitely encountered what I would call the best and the worst and all different shades of grey in between in terms of governance and culture. I've seen it from three different angles. Firstly, as the executive and CEO on the board. Secondly, as the regulator supervising over 100 insurance undertakings. And more recently, as INED, chair of the risk committee, chair of the board, and senior independent director. So I suppose what I'll do is focus on the issues as I see them based on my experience from these three different perspectives. But firstly, as an INED, just like joining a company as an employee, an INED needs to consider three different areas when joining a board. The first thing is the relationship between the CEO and the chair. The second is the relationship amongst the executive team themselves. And thirdly, the board dynamics, because getting this right can result in a smooth journey rather than a roller coaster journey. And basically, a board, just like any team in business, it's all about people. It's how they interact with each other, how they work together, all based on trust. And fundamentally, the route to success in any business is people and great leaders. And time again on boards, professional people who do show mutual trust, respect, integrity, and what I would call a clear absence of egos do tend to get it right. Board dynamics themselves are critical to ensure effective outcomes. So how does the board behave? Do board members share a common purpose and are relationships respectful and constructive? Do board members feel psychologically safe in the boardroom? And is the chair in control? And of course, does the chair command the respect of the board? As important is how the CEO takes interacting with board members. Is it an open and transparent approach, or does the CEO become defensive? Are the meetings well run and are they inclusive? One of the most significant changes over the past decade has been the increasing influence of the CBI. The Corporate Governance Code requires significant compliance in a number of areas. And one of the most important of these is measurement and looking at board behaviours and performance and culture. If we look at board performance, how effectively is the board reviewing the company strategy, and is it reviewing the risk appetite? Is the board involved in material decisions, and is it making decisions in the context of risk appetite? But as important is how is the board approaching the consumer, and how does the board view its stakeholders in general? And as always with any business plan, how is it monitoring performance against plans? And does the board take what I would call decisive actions when necessary? And this is an area in particular where all the company's eyes are watching the board. When a really important decision is going to be taken, how effective are the board at taking that decision? In the board behaviours, how effective is the chair, and does the chair lead the board? Is there a debate on every agenda item that's both informed and constructive? And is there ongoing effective challenge from non-executive directors? But overriding all of this is the cultural aspects. Is the board leading and establishing the firm's desired culture in areas such as mutual respect? So what does the CBI look for in a company? The first thing it looks for is adherence to the Corporate Governance Code. Secondly, it looks for financial and operational resilience and putting customers first. And thirdly, it looks for solid oversight by the board and board committees. The Corporate Governance Code itself sets out quite clearly the minimum code standards a financial institution should impose to ensure robust and appropriate corporate governance frameworks are in place. They define corporate governance as the procedures, processes, and attitudes to which an organisation is directed and controlled. They then define the structure itself, specifying the responsibilities amongst different participants in the organisation, such as the board, the stakeholders, and they lay down rules and procedures for decision making. The CBI then looks to monitor adherence to the code through their ongoing supervision. So how do issues arise? The first thing to say is usually it can happen in three different areas. Firstly, complicated board dynamics. Secondly, insufficient attention to the regulatory relationship and regulator expectations. And thirdly, what I call weaknesses in the governance framework. What can happen there is that companies can ignore the guidelines, either intentionally or unintentionally. The result of that is the CBI antennae are raised. They start digging deeper into the firm. It can result in corporate governance concerns, operational resilience or financial resilience issues, or it can look at consumer detriment. The result of that then is usually the CBI undertakes an operational risk assessment, or it takes an on-site inspection, and it then completes its review and issues or outlines the findings in the form of risk mitigation plans or RMPs. Two choices can happen when at this point. The first is that the board and executive become defensive. A blame game commences between the executive and the board. The engagement with the CBI becomes negative, threatening, and dysfunctional. The second choice is where effective boards see RMPs as an opportunity for improvement. And remember, companies all pay the CBI for supervision. So boards sometimes look and say, well, at least we get some free consulting from the CBI when they see RMPs produced. They also engage effectively with the CBI and manage the team relationship. But that is not to say that a company shouldn't challenge an RMP or the findings of a risk assessment. But the real issue is the effective challenge with the CBI. So how do you avoid getting to this position in the first place? Well, the most important thing is to stay ahead. Fundamentally, you need to undertake a gap analysis against your own corporate governance code, whether it's on the investment side, the insurance side, or the banking side. You need to do what you say you're going to do. So if you say you're going to review policies, for example, annually, then you need to ensure you do that. You need to have strong involvement in the ORSA or the ICAP process, whatever one is appropriate to your industry. You also need to be curious and be really curious in relation to the stress scenarios that are being put forward. And equally important is to get a risk opinion from your chief risk officer on proposals that are presented to the board. After all, the approach from the CBI is to ensure a risk-based approach to doing business. Therefore, the chief risk officer needs to be satisfied that the approach that's being taken is appropriate. As important is looking at emerging risks, looking at the recovery plan, the diversity, equity and inclusion position, and outsourcing with what I would say cyber and cloud in particular. As an INED, you need to bring the competence, experience and skills to do the job. You need to act and be seen to act independently. But you also need to satisfy yourself that the strategy of the company is sound and that the core business model is profitable and sustainable, because this is what the company is looking for you to do. You also need to ensure that there are clear structures and controls in place for effective governance, but you cannot rely solely on management representation. And a very important point is to champion adequate resources to ensure that there is independence of the three lines of defence. The need for adequate oversight, particularly with increased outsourcing, is a real focal point for the board and the CBI. So how does the board ensure it can challenge, for example, on the IT side or the cyber side? Most boards don't have expertise in that area, so they need cyber and IT training. Also, it's imperative that the board members do ask for external assistance when there is no expert on board. It's also important that the INED is not shadowing management, nor are they expected to know everything management knows. What we are tasked with is holding management accountable for their actions, and also for ensuring implementation of the agreed strategy and risk framework. The INED themselves needs to insist on high quality management information well in advance of board meetings or committee meetings. The packs can be a real bone of contention. Sometimes there can be up to 100 pages on a proposal with no clear recommendation. It is literally just indicating everything the executive knows about the particular proposal. A good proposal sets out the background, context, argument, and recommendation. And with that in place, the INED can then challenge constructively on options not pursued or on the basis for the recommendation. You need to make your presence felt by providing what I would call supportive challenge and satisfying yourself that the controls are adequate to address the relevant business risks. As chair of the risk committee and the board, what I find helpful is to have pre-meetings with relevant executive to prepare them for issues or challenges I wish to raise at the board or committee meetings. What this does is it results in an informed view rather than a knee-jerk response at the meeting. And as important is preparing for focus areas like outsourcing, what I would call the whole SEER side, the conduct side, the cloud computing, digitalization. So like what I would say, it's probably the same advice to management, to executives, to the board. You need to lean in, you need to be empathetic, and you need to practice active listening. You need to be curious at all times, whether it's at the board table or in your dealings with the CBI. From an INED perspective, it is true what they say that you need to keep your nose in and hands out, but you also need to try to have a mind that telescopes rather than microscopes. And finally, always do throw in a bit of humor. This can diffuse a situation very quickly, and that can happen either at the board table or around the executive table. So thank you for your attention, and now I'd like to hand back to Rowena.
Thanks very much, Sylvia. I think your comments there were invaluable, and I think it really sets the scene for the panel discussion that we're going to jump into now. I think, in terms of what you said, it probably makes sense to kick off maybe Claire with you on kind of the corporate governance and the company law side of things. And as you know, Claire, the central bank has put a lot of emphasis on the board's role in giving strategic direction and providing challenging regulated entities like Sylvia mentioned there. Do you think company law actually sets a similar standard for companies in general, or do you think the central bank's expectations are higher on that front?
Thank you, Rowena. So I guess as we all know, if we start at the very beginning, the Companies Act 2014 being the current applicable legislation, and a variety of other laws impose a number of duties on directors of Irish companies. These duties, and in particular the common law duties that have been codified in the 2014 Act, do serve as a clear signpost of the standards of conduct that the law requires of directors. The law is also clear as to what can happen to directors who act in breach of their duties. Unquestionably, though, the layer of regulation that the central bank's corporate governance requirements place on regulated entities imposes additional burdens on the directors of them. And Sylvia has already given us very good details of what they look like. What the central bank's corporate governance requirements do is they articulate with a lot more precision what directors of regulated entities are required to do, and they impose certain behaviours on them. And in doing this, they do eliminate the discretion that directors would typically have to exercise the company's powers, once, of course, they're doing this in the interest of the company and in accordance with their other duties. So while the reasons for imposing onerous corporate governance standards on regulated entities are very clear, directors whose key role is to ensure the company's prosperity while having regard to the interests of shareholders, but also ensuring that the requirements of a regulator are met, do face a challenging set of objectives and responsibilities. Also, the requirements placed on directors of regulated entities and the behaviours expected of them are done so by reference to particular categories of directors, so executive directors and non-executive directors. Yet the Companies Act doesn't generally make any distinction between the roles of each type of director, nor does it apply a different test to the duties and responsibilities owed by either category of director. So the Supreme Court has suggested that non-executive directors may have different duties to executive directors, but unfortunately it's offered little guidance on the nature of that differentiation. So I guess just looking at this a little bit, it's thought that different doesn't necessarily mean lesser, but also there is a case to be made for the law evolving along the basis of executive directors being more responsible for ensuring the company's business operates appropriately, and non-executive directors being more responsible for overseeing executive directors and executive employees by holding them to account for the company's operations. Exploring this differentiation slightly further, in insolvency situations, a director can be subject to a restriction order unless the court is satisfied, among other things, that the director has acted honestly and responsibly. There is some evidence in cases on director restriction orders that the Irish courts believe that this test should be applied differently when considering the actions of executive and non-executive directors, which is certainly progress in the right direction. However, we're not there yet. And in the meantime, the complexity of having a prescribed role, but a broad set of duties to fulfill, with no certainty of the test for fulfillment of those duties being applied in a manner that is relevant or proportionate to that particular role, does remain a challenge that needs to be navigated by directors, and in my view, particularly non-executive directors.
Great, thanks, Claire.
I was going to actually just briefly mention the behaviour of challenge as well, which Sylvia has also raised, just particularly against the backdrop that I've just described. The concept of effective challenge is clearly very important. And by challenging proposals and scrutinising strategies put forward by the executive, by asking questions as part of the board's decision-making process, non-executive directors are not only bringing their own sound, objective and independent judgments to the decision-making process, but they are continually learning about how the company's business operates, and they're properly informing themselves of the risks that need to be assessed before a particular course of action is taken. And this learning and information assists directors to properly understand what is in the interests of the company, and it helps them to act responsibly. So in my mind, the tool of effective challenge is critical to a non-executive director being able to fulfill their duties, and all of their duties, company law duties, duties imposed by other regulation, the expectation of regulators. But importantly, the reasons for providing challenge must be understood. challenge for challenge's sake doesn't achieve the same outcome.
Thanks, Claire. They're all really good points. And I think, the point you make around the distinctions between executive and non-executive, and like you mentioned, certainly from a regulatory perspective, and like Sylvia mentioned, when it comes to the role of the INED, we certainly see there's somewhat of a higher standard in terms of challenge expected, but it's important that it's not challenge for the sake of challenge. It has to be constructive challenge, I think. And I think, Peter, that probably leads nicely over to your area. And I know something we spoke about before, and a worry we've heard expressed by some of the US groups that we act for, is that, when it comes to minute taking and recording individual directors' kind of contributions to board minutes, that can be detrimental in litigation. How would you look at that concern from an Irish and an EU perspective?
Yeah, thanks, Rowena, and morning, everyone. I think this question, it really is a function of US corporate life and the US legal system. In the US, you have shareholder activism. It's quite an active area of litigation. And it's a real concern for corporates, be they regulated or not. But what happens in the US is, typically you will have a shareholder who has a large shareholding in a company, or more typically a group of shareholders coming together and bringing a claim against a company or its board. And that's where the concern can arise, or the question arises. On this side of the Atlantic, and certainly in Ireland, for very different other reasons, which I won't go into, it's not really a feature of litigation in Ireland. But I suppose what's concerning to directors, and as we're learning this morning, in recent years, there's an increased focus on sort of individual accountability, and regulators are requiring, firms, directors, INEDs, whether there's a difference or not between the two, to promote consumer-focused culture, promoting good governance. And, I was never good at maths in school, but my teacher always used to say to me, show your workings, even if the answer is wrong. If you show your workings, you might get some points. So look, the analogy is not exact to board minutes, but I think the point is that if you're trying to demonstrate or show to your regulator that certain issues were raised, were challenged or not challenged, depending, it's important that the board minutes demonstrate that and reflect that. So if I was an individual director, that's what I'd want the minutes to show, to reflect my engagement, my questioning, and all of that. So to go back to your question around risk and concern around being named, if I'm, as I say, a director, what am I more concerned about as my day-to-day job? I would say it's being able to show my work as opposed to not having my name on a minute.
Yeah, very, very good. I think, that's a good point, Peter. I think, again, it kind of goes back to the constructive point as well, making sure that, again, it's not just challenge for the sake of it, you're actually doing your job. And that's being demonstrated. Maybe, Liam, if we jump over to you, I might change the subject slightly and maybe focus on culture a little. In terms of culture, what do you think the key things are from a regulatory perspective? And I suppose the big thing here today is, how can a board demonstrate in practice that it's actually driving the culture of an organisation?
Yeah, thanks, Rowena. Okay, so I'm going to go on a little detour. So first of all, where did the title of this was Taming Tigers. So where did we get that from? We got that from, it's one of my crazy initiatives. It's a quote from Henry David Thoreau, a US philosopher, who said, "It is not part of a true culture to tame tigers any more than it is to make sheep ferocious." And I just thought that was striking in the context of the current kind of regulatory focus on culture as a way of transforming organizations, because you can argue that, like, firms in a capitalist economy survive and thrive through strong economic performance. And it's, there are these, there are economic theorists who would say this is part of evolution and natural selection of companies and all the rest of it. So are we trying to turn firms into creatures that they are not naturally meant to be? Park that thought out there for a second, because I think we'll come back to it possibly through some of the Q&As. But look, it's too far. We've gone too far in the regulatory direction towards a focus on culture. We've got very distinguished people like Andrew Bailey out there, as well as our own senior regulators, Derval Rowland and co, who are very much identifying culture as being a key determinant of subsequent issues in terms of market engagement and consumer treatment. Bailey, in some of his published remarks a couple of years ago, said that failures in culture would be manifested in 4 areas: governance, remuneration, risk management, and tone from the top. And he said that's what we as regulators are going to be focused on. But if you're on the other side and you're trying to anticipate, if you're a firm and you're trying to anticipate how the regulator is going to judge your culture, culture is a very nebulous concept. So when regulators are in there actively trying to supervise culture and identify areas where culture may be deficient to achieve good regulatory outcomes, what are the practical steps that you as a regulated firm can take to put yourself in the best position to meet those expectations? So I would say, we're going back over, and it is different to governance because governance is prescriptive. We have a set of requirements. We can, as Sylvia said, do a gap analysis. We can identify areas where we can tick all those boxes and show that we have met or exceeded those requirements. Culture is a much more overarching term, and there are indicators that the regulators will pick up on that go beyond the prescriptive governance requirements. But a culture of challenge. Do we have meaningful challenge? How can we demonstrate that? It has to start with the board because the tone has to start from the top. How can we show that through the board papers? Because obviously the regulator is not going to be sitting in on every board meeting or every committee meeting and be able to actually judge the quality of challenge that takes place in person. Individual accountability is one of the factors. Is there a culture of holding individuals to account? How the boards of Irish regulated firms engage with the IAF and SEER is going to be key, I think, to judging whether there is a full culture of individual accountability within a firm. Do we have a sufficiently diverse range of thought on our board? And is that manifested in the skills matrix and in the succession planning? So is it real? Is it translated into action points as opposed to just talk about diversity and inclusion? Are we demonstrating that that's part of our strategy and our objective setting? Do the second and third line, Sylvia talked about this, do the second and third line functions have sufficient status and resourcing to act as effective checks? How does the board reinforce their role? How does the board champion their role? How does the board press for them to have the resources that they need? Especially in an environment, as we all know, where there's a war for talent, and it's very difficult to actually recruit people into a lot of these functions. The remuneration system, how does the board engage with the remuneration system, either directly or through the RemCom? Does the system adequately reflect non-financial performance? Is the board and the RemCom engaged with how the system actually works, as opposed to looking at the remuneration policy once a year and getting a certification that, yes, we're satisfied that it's ticked all the boxes on the EBA guidelines or whatever are the relevant guidelines. So, I mean, there's a multitude of factors where a board can demonstrate that it is engaged with and is overseeing and monitoring and helping to shape the culture of the organization. But unfortunately, it's not something that a board can engage with using a checklist approach.
Yeah, I completely agree with that, Liam. And I think, Sylvia, actually, it'd be great to get your thoughts on that. I mean, look, like Liam said, diversity and inclusion have been a major focus for the central bank. And, there's been many regulatory speeches, dear CEO letters on the topic. And it's also an important board responsibility, like you mentioned, when it comes to kind of setting the culture of an organization. What would you say to firms, like to boards and senior management, around what they would need to do in this area? Oh, Sylvia, I think you're just on.
You're on mute, Sylvia.
Thanks. Okay. What I was just saying, Rowena, is I'll answer your question, but then I think I might follow up on a question that's come through on the chat button. Just in relation to diversity and inclusion, I mean, there's been a significant shift in relation to companies' responses, some of which I agree with and others I don't. I do think that targets in particular areas are really important in terms of diversity. This quota position I'm not in favour of, but then the jury's out in terms of different perspectives. I think the whole focus on not just gender, thought diversity is just so important in the board and in the management team. Also, I think there's been a fundamental shift, I suppose, post-COVID in terms of people and their view of, I would say, their work-life balance and what's important to them. And I do think the companies need to have an increasing focus on the wellness agenda and the work-life balance agenda to maximize the contribution from the staff. So I suppose what I'm seeing is I'm seeing companies that are taking a real interest in employees. They're getting engagement pulse surveys to indicate what do employees want to see in terms of the diversity and inclusion agenda. And I suppose, somebody said to me, which I thought was a really good indication of what D&I is, it's kind of diversity is being invited to the dance. Inclusion is being asked to dance when you're at the dance. So it's actually, when you think of it in terms of how your company, it's all very well, yes, we do great, now we have females, but actually, are we including the females in at the senior table? Are we including them on the board? Are we actually promoting females into positions of responsibility? So the various, I suppose, they're different, what I call, whether it's LGBTQ or it's the looking for caring for the elderly or caring for children, to ensure that companies have an open and transparent approach to inclusiveness for its employees within the workforce. Just following up on, I think it was Siobhan O'Leary, if I remember rightly, just she had a question in the chat about the whole CPC agenda. And I have to say that area, both from the CBI perspective and from companies, I can reassure you, Siobhan, that it is not lip service anymore. The CBI have transformed the consumer agenda. There's huge heightened, approach to customers, and the whole basis of the SEER approach is basically based on putting the customer first. The other side within the board, suddenly there you do have, and it is a very delicate balance between the prudential supervision and the conduct supervision. And, if you were to put the customers first, for example, in every area, then the company would go bust. You wouldn't have a profitable business. So you have to be very careful. But I suppose the approach using culture is that if you have a business that is run by an effective management team that has, I would say, at its core, the best interests of the customer and the company at heart, then you can be assured that the customer, the conduct side will be positioned at front of mind.
Great. Thanks, Sylvia. That's really, really helpful. And thanks for already taking one of our Q&As. That was great. One off the list. Claire, on your side of the house, again, looking at good culture, how can a firm, I suppose, demonstrate or evidence good culture when it comes to its corporate records? Like, are there practical steps that a board and a firm can take to put it in a better position to drive a good culture when it comes to corporate records?
Sure, thanks, Rowena. I suppose interpreting corporate records kind of broadly, I'll start with the obvious. I'll start with policies. So as we all know, the active exercise by the board of its responsibility for adopting and ensuring the implementation of company policies and codes of conduct is key. And living by these policies and regularly monitoring and reviewing them, it sends a clear message that the board is committed to creating the appropriate culture. Evidence of the application of policies in this way can also assist a company and its directors to defend themselves should it arise that an offence under particular legislation like anti-bribery and corruption, health and safety, competition has been committed. And in terms of other documents, ensuring that the roles and responsibilities of the board committees, senior management are clearly documented ensures that no single person has unfettered control of the business. And this allows the various parties to understand the delineation between their respective roles, which allows for more efficient engagement, clearer communication, and this all in turn facilitates a healthier relationship between non-executive directors and the executive. But board papers also merit mention, and I'll likely repeat Sylvia's great guidance on this because I feel particularly strongly about board papers. So the importance of board papers in enhancing a culture of positive and constructive engagement between non-executive directors and the executive shouldn't be underestimated, particularly in circumstances where the majority of the members of the board of a complex organization are non-executive directors, for there to be productive interactions and effective decision-making, and so that the board and board committee meetings run efficiently. The manner in which information is presented to the board is key. Directors need to understand why a matter is being put to them or information is being presented to them. They need to understand the context. They need to be able to assess the risks of a proposed course of action. They need to understand what the ask is of them. They need to know if the course of action is recommended by the executive. Senior management, on the other hand, will also want to be confident that the board is prepared to objectively consider proposals. So adopting a practice of ensuring that board papers are consistently prepared, clear summaries of the key point that the board needs to be aware of, and the ask of the board being called out, with these papers being sent out in good time, every time, allows directors to be properly prepared for meetings. And all of this allows for constructive and efficient discussions at board meetings. It helps with effective challenge, and it also develops a culture of trust between the board and senior management.
Great, thanks, Claire. Yeah, I think it's such an important point that for directors, things aren't lost in the weeds of all the board papers they receive. Messages have to be clear. And, you know, for directors, when they're being asked to make a decision, it's clear what they're being asked to look at and what the recommendation is. I think, Peter, it'd be great to get your input on culture as well. Look, and like everyone has mentioned, the tone from the top is crucial in terms of culture. At board meetings, do you think there's any risk with, you know, if there's an open culture, can that give rise to a litigation risk? Can firms manage that from your perspective?
Yeah, so I think, I suppose to put it in context, as a disputes lawyer, you hope for the best for your client, but you plan for the worst. And certainly the common mistakes I would see, and they're all very well meaning, and I think they're just sort of, people fall into various things, are sort of threefold. You know, board and senior management seem to, unfortunately, fail to understand legal professional privilege and how that can be deployed and when it can't be deployed. So, there's a tendency to think because your in-house counsel is copied on a particular email or included on a particular report, that means that it's privileged, it's great, that gives us a level of protection. And the other thing I'd say on this point is that, you know, just because a document, and it's usually more senior members of institutions you find this conversation with, is that just because a document says confidential on it, it doesn't mean you can just stick it in the drawer in your desk and you don't have to show it to your regulator. That's not how it works, unfortunately. I mean, privilege as a concept, we could do a whole session on that. I'm not going to bore everybody on it. But in effect, if you can properly claim it, it allows you to legitimately hold back documents from your regulator or any court proceedings. But just because, as I said, you know, an in-house counsel is involved in a particular matter doesn't mean the privilege is going to apply. And, you know, the Irish courts do differentiate between legal advice versus legal assistance. So it depends on what role your in-house counsel is doing at the time as to whether privilege may or may not apply. You know, and I think boards need to be careful that, as I said, you know, for really good reasons and, you know, with the best intentions, and to your point around this new era of all these buzzwords of openness and good culture, there's nearly an internal rush when a particular issue arises, or if there's a suspicion of a particular issue, that, you know, they run down a particular road without first thinking what the outcome could be. So my sort of, you know, 10 cents on this particular point is that, you know, it's important to take a pause, to take a step back, engage with your in-house counsel function if you need to, engage with external counsel if you think it's worth a 20-minute phone call, And we've all had those phone calls from clients every other week. They think they have an issue and you just give them a steer, because I think it's important to, understand what that path might look like, because I think too often well-meaning boards are inclined, to either engage in a particular task internally or more worryingly engage, third-party consultants to prepare certain reports or something without actually thinking, where is that going to end up? And just to do that pause, at the outset, I think will formulate how you go about it. Just to, I suppose, give a practical example of this, and it's a good few years ago now, but we were engaged by a financial institution to look into a particular issue. And following the initial engagement with the client and the to and fro as to what they actually wanted, it became apparent that actually the outcome of our engagement was a report to the CBI that we would hand over. So because that was understood at the outset, a strategy or sort of a terms of reference was agreed between us, the client, and more importantly, internal stakeholders. So everybody understood the path of travel, which then allowed us to manage issues like privilege and all of that, because everybody understood the framework within which they're operating on. So I think to the extent that you can ever avoid litigation, which is, it's just unfortunately a part of life, and thankfully it is, otherwise I'd be out of a job. But it's important to take that step back, understand the context you're operating in, because that will then inform how you go about your task.
That's great, Peter. Thanks a million. I think, this probably leads into the question I have for Sylvia next. It's important that everyone is on the same page, I think, particularly when it comes to risks like that. Everyone has to be kind of pulling towards the same goal at the end of the day. And Sylvia, I think on your side, you made a point earlier about, trust between the board and senior management being key to positive culture. I think it'd be good to get your thoughts on that now, if you'd like to expand on that a bit, given kind of Peter's comments there.
Yeah. I suppose that there's trust. I mean, it is, we all know when trust breaks down, it can become toxic. But it's actually, when you look at what does really good trust look like, and I suppose it's in keeping with the shift, as I say, from the style of management over the past decade. We sort of gone from very much the command and control level of management to now it's collegiate, it's collaborative, and in an environment where you've got that mix, and oftentimes you can have a mix of individuals who are very much, their style of management is command and control. You have a chair who's collegiate or collaborative. And suddenly when you get that mix within a board and you have differences, then trust can break down. But what really works is where you have a collegiate chair who is actually what I would call competitive and driven, and they want to make the company work. They want the board to be effective, and they want to lead. So they're driven to be ahead, but they're actually very conscious and very respectful of all the players around the table and their individual contribution that they can make. And I suppose that for me is what I've seen as the best in class, is the chair that actually doesn't give their view until they've heard all the views around the table, but they have an expert ability to be able to lead the board forward, and in an environment where everybody feels they've contributed and they feel good about the approach that's going to be taken. And I suppose just to take, and it's about what I call mix of skill sets. And I know, I think it's, there was a question in the chat as well from Mr. O'Dwyer, I think it is, just about diversity. And he said, diversity, yes, no experience, no. And I have to say, I would challenge you, because in my experience, everybody, if they're, no matter who they are, they have experience in something and they're good at something. So if you've got a board member who is the consumer champion, for example, now they may be the consumer champion from Dunn Stores or from Diageo, but they have spent their career looking after the consumer. They're a really valuable input and insight within a board. But I would agree that it depends on the size of the board, because the central bank expects the board to have a mix of skills that are effectively able to drive the agenda and drive the strategy forward for the business. Therefore, you're going to need the accounting expertise, you're going to need, whether it's insurance, banking, or investment expertise on the board. But having somebody who doesn't have the sector-specific experience can actually open the mindset of the people on the board. So I would, Peter, challenge you in relation to that particular point. But thank you for the question.
That's great. Thanks, Sylvia. And thanks again for taking another one of the Q&As out of the list at the end. That's brilliant. I might pivot slightly, but stay with culture. But Liam, remuneration is a key part of culture as well. And I suppose the question for you, Liam, is how do you think the regulatory approach to remuneration can impact on how a board does its job? It'd be great to get your thoughts on that one.
Yeah, thanks, Rowena. I mean, there's such a lovely segue from what Sylvia said. Really, the recipe for success is the driven CEO, the purpose-filled, driven CEO or chair who works collegiately and respectfully of other stakeholders, and where everybody is encouraged to contribute, everybody's voice is heard, and everybody feels good ultimately about the direction of travel, as opposed to the dictatorial CEO or the dictatorial chair. And in a way, the remuneration rules are kind of designed to incentivize, that inclusive approach to management and that avoidance of laying stress through the incentive system on one aspect or one attribute of management or of stakeholders to the detriment of others. I mean, we tend to be a bit obsessed in this country with the bankers' pay cap and the 500,000 and the 80% bonus cap and all of that. But it's important to remember that the regulatory approach to remuneration is actually much broader than that, and we have pretty detailed guidance for banks from the EBA, very detailed guidance, somewhat less detailed for insurers and MiFID firms from EIOPA and ESMA. And broadly, as we know, they all do similar things. They limit the proportion of variable pay or bonus to fixed pay, require a substantial part of variable pay to be deferred, require that variable pay be subject to performance-related adjustments, and so on. I mean, the board has clear responsibilities in this area in terms of its oversight of the system and of the operation of the system in practice. But in answer to your question as to how that can impact and how the board does its job, it will clearly have impacts on the day-to-day work of the board, depending on the overall nature of the organization and its familiarity with these restrictions. So if you're a director of an Irish subsidiary of a global group that has a limited EU footprint and limited familiarity with these restrictions, you may find that there is a communication exercise that needs to be done back to the shareholder in terms of explaining why their global approach to remuneration and incentivization is simply inappropriate from an Irish regulatory perspective or a European regulatory perspective, and that this is not just a matter of hard and fast proportions. You can't have bonus exceeding 200% of fixed pay. You must have 40% of bonus deferred for 3 years and all of that. It's not just about numbers. It's also about metrics like including non-financial performance and customer outcomes in staff evaluation for the purposes of calculating variable remuneration. That can be much harder to communicate to shareholders who don't have experience of the EU system. But the key impact, I think, which we're all seeing daily, is the challenges that are posed by the tight labour market. And financial services firms are competing for talent with tech firms and firms in other parts of financial services that are not subject to similar kinds of restrictions on remuneration. And in those circumstances, what can the board do? The board needs to demonstrate that it is fulfilling regulatory expectations on the design of the remuneration system and application of the remuneration system, but at the same time, ensuring that there is appropriate resourcing for the organization. And I suppose this goes to a point Sylvia made earlier about the non-financial rewards, the non-financial incentives, and really strategically driving the organization to think about its overall employment culture and to think about how it can attract and retain staff other than by the direct financial incentives, which I think are just going to be key for regulated firms to keep the appropriate staff complement going forward.
Yeah, completely agree with that, Liam, and certainly, something we see our clients grapple with all the time is trying to, deal with like staff losses and challengers coming into the market who are subject to different remuneration rules. It's a very hard one to get right. I'm conscious of time. We're nearly at full time, so we might just flick up the poll results from the start of the webinar. We just have a quick look at those. So for the first question, I think a lot of organizations have said that they've increased the diversity and inclusion in their workforce. So that's quite positive. Most people answer substantially or moderately over the past few years, so that's quite positive. Second question, do you agree that regulatory remuneration rules can improve governance and culture? Again, I think overall the audience was in favor of that and agreed with that statement. Thirdly, do you think the central bank's continued focus on effective board governance and challenge distracts from the board's ability to oversee the day-to-day business of the firm? Bit of a mixed bag on this one, but overall coming out as no. And then lastly, how would you rate the levels of trust between your organization's different stakeholders? So I think overall that was a positive. There obviously seems to be good relationships between the various stakeholders in the firms who are in the audience today, which is quite positive. We have 2 minutes. I might try get one Q&A in if I can, and apologies. I'll just have a quick look down through the questions we've received so far.
There's one there from Dermot O'Kane. I might give a quick response, Rowena, just in relation to proportionality. You raise a really good point. In a small company with a small board, the whole governance and culture is particularly bad. But what I would say, the same principles exist, and it's back to I suppose the beginning where I said the relationship between the chair and the CEO, the executive team themselves, and the role of the chief risk officer. It is extremely important, and in a small company your most important focal point needs to be on outsourcing and oversight of outsourcing, because as a small company in a regulated environment you do outsource an awful lot, and that needs to be overseen by the executive and the board.
Great, thanks. Sorry,
Can I jump in? I know we're running up against time, so I would say very much, but just one thought just that comes out of the poll, but also there's a question in the chat, I think, that comes from Sophie, and it goes to this question about the effect of the central bank's focus on governance and culture and whether it is overly intrusive. Now, our poll respondents said no, that they didn't think that it was distracting or creating an impediment to boards' ability to get on with the job. We all know, though, anecdotally, as advisors, as we talk to people, that there are complaints that boards are finding it difficult to allocate the time to driving strategy, to taking really to looking at the high picture. So that is a balance that needs to be struck between paying attention to the sort of prescriptive requirements of the central bank and making sure that the systems are all in place and controls and all the rest of it, and making sure the board gets that time to really take ownership of the big picture strategy. Sophie's question: is the CBI is CBI oversight making it legally riskier for companies to do business? No, I don't think so. I don't think so. I think it's more a question of whether boards are able to operate effectively at at the strategic level than whether CBI oversight is in itself giving rise to legal risk. I wouldn't say that's the case. I don't know whether anybody wants to chip in on that. Sylvia, I don't know whether you'd agree with me, or maybe not. Maybe that's an unfair question.
It is. I think your summation is quite correct, Liam. But my sense is that as a board member and as an INED now, you have to be aware of what you're taking on when you take on a position on a board. There is much, I suppose, there is heightened scrutiny from all quarters, whether it's legal, regulatory, or the whole consumer side. So, I won't say you walk in with your eyes wide open in terms of what you're walking into.
Thanks, Sylvia. I think we're just past 12, so we might leave the Q&A there, and I'm keen to kind of let everyone back to their day jobs. I'd just like to finish off by thanking Sylvia for joining us today and sharing her thoughts. They've been invaluable, and I'd also like to thank Peter, Claire, and Liam for doing the same. We'll be running another or further sessions on kind of regulatory key issues over the course of the year and later on this year. If you have the time now, a feedback survey is going to pop up on your screen when the webinar ends. So feel free to suggest future topics that you'd like us to cover. And I think that just leaves me to say thank you very much to everyone for joining us today, and see you all soon.
Great.